Welcome to the first edition of the SJB Legal Bitesize Updates. My name is Henry Vanderpump and I'm going to give a quick talk on the recent High Court case of Williams Henry and fundamental dishonesty. This is particularly relevant to personal injury and clinical negligence practitioners. This was a case involving catastrophic injuries and a finding of fundamental dishonesty. The dishonesty was pretty bad. I'll just give some examples. The claimant said she had a heat intolerance, but had been posting on social media about going on hot holidays. She said she couldn't eat curry, but was seen eating curries. She said she couldn't drink alcohol because of her brain injury, but was shown drinking cocktails. She said she had noise sensitivity, but was at a Spice Girls concert. That's amongst other elements of dishonesty. Richie J had no hesitation in finding fundamental dishonesty. But what's interesting about the case is the 8-point test that he comes up with for practitioners to apply in considering whether there would be substantial injustice in dismissing the whole case. I'll just read through this to you. First, the amount claimed when compared with the award should be considered. Second, the scope and depth of the dishonesty. Was it minor, moderate, or gross? Third, the effect of the dishonesty on the construction of the claim. Fourth, the scope and level of the claimant's assessed genuine disability. Fourth, the nature and culpability of the defendant's tort. Fifth, what the court would do in relation to costs if the claim were not dismissed, interim payments and how the claimant could afford to pay them back, and finally, the effect on the claimant's life, housing, finances, and ability to work. Now, I'd always assumed if your claimant was fundamentally dishonest, then the circumstances where it would be substantially unjust not to dismiss the case would be few and far between. But I think I really need to reanalyze that position in light of these criteria. If I had a case where there was no hope of paying back the interim payment by the claimant, or it was a hit and run case by a defendant whose conduct was awful, or my claimant was going to lose their house if the claim were dismissed, or have to live on benefits, or miss out on necessary therapy, or if the dishonesty was fairly minor in the scheme of the whole case, if I had those kind of facts, I should really push back hard against the defendant and the court on substantial injustice. And also, perhaps the better option would be to suggest to the court not dismissing the whole claim, but perhaps reducing the award for costs on the basis of conduct. We would welcome your feedback on this first edition. If you would like us to cover any particular subject, please get in touch with Chambers.